Hi, I'm Steve Carlson, a 2016 presidential candidate with a case about independent voters at the U.S. Supreme Court. Well, the state of Minnesota has admitted to certain facts and law in this voting rights case about violations by the quota system of electing delegates, by manipulation of public information to favor certain parties, and by the abandonment of enforcement duties by the Minnesota courts and blocking of the jurisdiction of the U.S. Senate in 2014 and in 2012 the U.S. House. This has resulted in, among other things, the loss of the nation's largest major political party with direct access to the general election ballot in federal elections. 53% of the voters identify with straight-up independence of the two major parties, or with small or third parties. So there's 45% that just want independence, another 8% for small and third parties, and then combined, the Republican and Democrat parties nationwide are just 47%. So they are outnumbered. Now, I filed this motion to the Supreme Court to send this to the Senate with the discovery provided by Minnesota law, by simply ordering Minnesota's current governor, Mark Dayton, to withdraw the certificate to Al Franken, which was made while this contest was pending and therefore unlawfully. So these corrupt practices and constitutional violations I have stated above can be remedied by the Senate, and then, again, if appropriate, by the U.S. Supreme Court, and that is through the election contest, which was duly filed. Now, I asked the court to allow 10 days to respondents to respond to the motion before the court takes judgment, and then to grant or deny the motion. It is based on that is the Supreme Court's, distributing it for the November 13th conference without asking for a response from the state and Al Franken. Petitioner and presidential candidate Steve Carlson files this motion for emergency and injunctive relief pursuant to Rule 22.2C motions in order to preserve the constitutional status quo and restore the rights of independent voters, which have been and will be further irreparably injured if the court does not act. And for reasons discussed herein, movement urges that the pending motion or petition for certiorari regarding an election contest is the most extraordinary of circumstances, where under the United States Constitution, no judge, including this court, has the power to hear a motion for a stay, because it is related to and part of an election contest in which the only judges are the U.S. Senate. The election petition is a part seeking to enforce the contest tolling provisions and the Senate rules of certification, and specifically, Mark Dayton ignored those because the tolling provisions block him from issuing that certificate till the contest is adjudicated and finally determined. Now, that didn't happen, and that's uncontested. It did not happen. And the Senate rules also require that what he says to them, what he gives to them with the certificate and with the cover letter that he gave to them, be true and conform with the requirements. And in that, he said that he had not, there were no contests pending, and therefore it was not necessary to look to these questions that I've raised, and Al Franken could just take his seat. So these are most extraordinary circumstances. Now, in Stephen L. Morgan versus United States of America in the D.C. Circuit in 1986, they applied Baker versus Carr, which defined what is a political question and therefore could not be adjudicated by the courts. And they said that in this case, that no court, including the U.S. Supreme Court, including the D.C. Circuit Court, or including the state courts, can sit as a judge where the Senate is solely empowered to sit as a judge under Article 1, Section 5 of the U.S. Constitution. And so Under that, this court can only act to aid the fulfillment of that contest procedure which was begun in Minnesota by reinstating that contest, and may not supplant or usurp the Senate's jurisdiction by adjudication. And the Minnesota courts have no power in this matter except for those duties prescribed in Minnesota Statutes 209-12, that's congressional office, insofar as that procedure also does not usurp the jurisdiction of the Senate. And the governor has, in fact, made a change that would usurp that power, but that should not be applied to this 2014 contest. But he changed that law in 2015 to take away the power of the Senate. Now, the whole purpose of this entire proceeding is to bring before the Senate the points raised in the contest, timely filed December 2nd, 2014, against Al Franken, and furnished to the Secretary of State, Mark Ritchie, for whom his successor, Steve Simon, has been substituted. But those points have been unconstitutionally blocked by the Minnesota courts, the governor and chief elections officer, Ritchie, from reaching the Senate according to the manner prescribed by the Minnesota election laws, and those laws are enacted under the broad grant of authority from the U.S. Constitution, Article 1, Section 4, and that's described by a case called Smiley versus Home, also petition, also certiorari to the Supreme Court of Minnesota. That's way back in 1932. The state didn't quite get it right. Now, this court has asked, the Supreme Court has asked for your aid to allow this procedure to proceed to the United States Senate, and that's what this motion is about. So I do apologize. I have to kind of jump around on my computer occasionally. And this has been a rush. But as I said, these voters' rights will be irreparably injured if the court does not allow this process to go forward for a number of reasons, including continuing violations of the U.S. Constitution and disregard for the law. Now, the simple three-part motion is one, that the election contest filed timely December 2nd, 2014, and interrupted by the premature and unlawful release of the election certificate of Al Franken, December 19, 2014, be reinstated and allowed to run its course, including a full and fair opportunity to present evidence to a Minnesota court for certification. And in conjunction with this, to forbid the Minnesota governor and Secretary of State from applying the results of the 2014 elections, to take away Independence Party major political party status for the 2016 elections until such time as the lawfulness and constitutionality of the contested election is considered by the Senate and thereafter by this court. 2, to order the governor, pursuant to Minnesota's contest tolling provision and U.S. Senate rules, to withdraw said certificate and not reissue it until the contest that was interrupted December 19th is completed. That is to say, in accordance with the U.S. Constitution, the United States Senate rules, and Minnesota law, and not to implement the 2016 repeal, it's actually a 2015 repeal of the tolling provision during federal election contests until such time as this court has determined that repeal's constitutionality. 3, that the Supreme Court take no further action except to note certiorari and grant IFP until the Senate is able to receive and act on the evidence of irregularity in the conduct of an election and grounds of deliberate, serious, and material violations of the Minnesota election law, and then review Senate results for constitutionality by allowing the parties to brief that whether or not the Senate acts on receiving the contest. And when I say Minnesota election law, this must absolutely be read as including federal election laws and Constitution for 2 reasons. Firstly, because the state legislature has no authority to create election laws for Congress, except insofar as authorized by that section. And secondly, because the section gives to Congress the power to regulate and modify state election laws, and of course other applicable provisions such as the 14th and First Amendments of the Constitution must be complied with. Yet no Minnesota court or official would address anything but state statutes, which they have not administered as federal election laws, although the federal law and Constitution were constantly cited and raised. So I just wanted to define, when I say Minnesota election law, I also include the Constitution and federal laws regulating Minnesota elections. Now, in conjunction with this, to forbid the governor and secretary of state from applying the results of the 2014 elections to take away the Independence Party status, as I have said. So, petitioner and voters on whose behalf the petition is brought, and I've defined that as follows. For purposes of this motion, when I use the term voters, I stand for all individual voters, small and third parties, and candidates supported by the association of these voters, and not the two major parties and candidates who take their place on the general election ballot due to the machinery and resources of those parties, such as caucuses and conventions or primary elections. And so whenever I use voters, that is what it is going to mean here. And again, I don't have, I'm actually reading to you from the motion that is filed with the Minnesota Supreme Court. I just filed and served that yesterday on Friday. I guess that would be the 6th. And I'm hoping that they have it scheduled for, as I said, for conference on November 13th, if they leave it on the docket for that. And they may. Now, my argument is that the petition that is brought is likely to succeed on the merits of this petition. I'm likely, and the petitioner and voters are likely to suffer irreparable harm in the absence of preliminary relief, getting this to the Senate. Remember, the caucuses are starting in February. That's about 3 months away. 3, the balance of equities tips in favor of this motion, and 4, granting the relief sought is in the public interest. And in that, I rely on a U.S. Supreme Court case called Winter versus National Resources Defense Council, just decided in 2008. And that apparently, modified the, did modify the standards for this kind of motion. Now, the uncontested facts before this court include the following. December 19th, 2014, without giving notice to petitioner, the Governor and Secretary of State of Minnesota signed, sealed, and submitted to the United States Senate, and that is to the Secretary of the U.S. Senate, Nancy Erickson, an election certificate for Al Franken as senator. And I want to tell you a little bit about that certificate. The required language of Senate Rule 2 certified that Franken was duly chosen by the qualified electors of the state of Minnesota, a senator from said state, unquote. See petition at 32. Now, duly means upon a proper foundation, as distinguished from mere form, according to Black's Law Dictionary. And obviously, he was not duly chosen because they didn't follow the law. That's the foundation and not just the form. They have to follow the law. And it was with a cover letter falsely claiming that no contests were pending and that Franken should take office on January 6, 2015. Now, because they followed the statute, they actually put January 3rd, but that's technical. But only after January 5th was notice of this action of December 19th given to me. And I had thought the contest was still pending, not judicially determined, because only December 22nd was what they did was they divided the contest so that they could get a preliminary partial order, which they pretended would allow them to send this certificate without completing the contest. And it was mailed to me only December 22nd by the Minnesota Supreme Court panel, which they had appointed to deal with this responsibility. Now, I did immediately complain and appeal to the Minnesota Supreme Court, which I call the Minnesota Court, in less than 10 days, on December 26th, in fact. And I have included that appeal to the court so they can look at it. From said order, that the panel had violated the Constitution and Minnesota election law by separating out the points regarding the validity of the election and failing to pass on them, or to pass them on to the Senate. They're not allowed to pass on them, but they need to pass them to the Senate because they're the ones with the jurisdiction. This is required by Minnesota Statutes 209.12, again, congressional office. Instead, ruling on the one point that was uncontested, which was the accuracy of the canvass itself. My points had to do with the conduct of the election. The points raised challenging Al Franken's right to office on the basis of this allegedly invalid election. See 209.12, sentence 3. Nowhere did the December 26, 2014 appeal for mandamus, because it was both, indicate any awareness that the governor had already granted and issued the election certificate December 19th to Franken and the Senate, because I did not know. I also maintained, quote, that the distortion in the count of the Independence Party as a result of said violation cannot be separated out from the conduct of the Senate campaign and its election results. Points reserved by the U.S. Constitution, Article 1, Section 5, to the Senate itself in the first instance, and therefore no state court can rule on these matters until the Senate is finished with it, unquote. Now, because the Minnesota court received this, then on January 2nd, 2015, a Friday of the long holiday weekend, the court asked the parties to brief by Monday, January 5th, one day before Franken would be seated based on the governor's certificate. The question of whether the certificate could have been lawfully released, as it was, December 19th, before the time for appeal from the panel's actions had expired, and any appeal determined. See again 209.12. Again, the issuance was done without my knowledge or notice. I did not receive the court's January 2nd order by that time because I received my notices by mail. I did not respond because I had no notice. But nothing the court could have done January 5th could have affected the wrong that was already done December 19th, which I had then just learned of, before the Senate acted on its false certificate that it had received January 6th. It was not my duty to try to correct these misdeeds. It was the Minnesota court's duty to follow the election laws, which are mandated by the broad grant of authority under Section 4 of the U.S. Constitution, Article 1, and not their own ideas. But the Secretary did respond through the Assistant Attorney General Nathan Hartshorn, who has also represented the governor in the petition that is whose review is being sought by this current pending petition for certiorari to the United States Supreme Court. And he answered my December 26th concerns that Ritchie might prematurely and unlawfully issue the certificate based on the bifurcated and preliminary partial order mailed to me December 22nd, which he had already done December 19th. So the issue raised by the court below was whether Minnesota law and the U.S. Constitution required Dayton to withdraw the unlawfully issued certificate and reinstate the contest. That court has never opined on this, however. They just asked for it to be briefed, and then they have issued no opinion. And in that January 5th response, the Secretary sought to justify the governor's actions as follows. This is also cited in an exhibit to the petition before the court. Quote, on December 2nd, 2014, contestant appellant Stephen W. Carlson, appellant, filed a legally baseless contest of the 2014 Minnesota general election for Senate. The three-judge panel trying the matter filed its final judicial decision pertaining to the Senate contest on December 19th. Concluding, and remember the hearing was on December 18th, concluding that contestee respondent U.S. Senator Senator Franken, received the highest number of votes legally cast in the election, and is therefore entitled to receive the certificate of election, and directing immediate entry of a judgment to that effect. Later, on December 19th, when appellant had made no request to stay further action pending an appeal, Governor Mark Dayton prepared and signed, and contestee respondent, Minnesota Secretary of State Mark Ritchie, the Secretary, countersigned the certificate of election for Senator Franken. For the reasons provided above, the Governor and Secretary correctly issued a certificate of election to Senator Franken December 19, 2014. So you can't really say I haven't proved the facts of this case. I've provided a brief to the court where they argue that they did do that December 19th. Then the petition to this court details in the statement of the case how from the very beginning in the contest and in the appeals and petitions in the state courts, the federal constitutional claims and violations of election laws were properly and repeatedly raised, and yet none of the courts below have so much as mentioned those constitutional requirements in their adjudication. Minnesota courts are not allowed to adjudicate congressional election contests because of the election laws prescribed, that means written beforehand, and then they have to be followed, and Article 1, Section 5, see Morgan and cases therein. And even the vote count, though Minnesota law appears to say the court below, the Minnesota courts could determine it, actually must be determined by the United States Senate and not any court. Article 1, Section 5 of the U.S. Constitution. The petition and this motion rest on Anderson versus Chela, a 1983 case in which this court established independent voters and their candidates and parties as a protected class, as against Democrats and Republicans. Now that is remarkable. That is what the court has done. These two national parties have been found to discriminate against voters by manipulation of state laws and state actions. And here's the discrimination. Combining the First and 14th Amendments, the Anderson court literally created a protected class among the voters, based not on race, etc., but on membership in a potential class of voters who could associate to choose a candidate on the ballot that best represented their views. Isn't that what our democracy is all about? Thus, it is a combination of the Association Clause of the First Amendment as well as the Political Expression Clause, by which I mean the clause that refers to the vote, the information provided by the candidate, and his campaign. Protection of such discrimination or against such discrimination has been extended to Republicans, but registered independent, in Tostian versus Republican Party, a 1986 case. So they apply this independent voters case to protect us, to protect the Republican Party in that case. And then the Central Democratic Committee of San Francisco County in Yale Fong versus San Francisco County Democratic Central Committee in 1989. So here they take this case that relied on the First Amendment to protect independent voters and applied it to the Democrat Party so that they could endorse people. And the California had a law passed that you couldn't endorse people. It may have been a policy of the Secretary of State, but it was state action. Now, in this motion and petition, you are being asked to extend protected class status to the Independence Party, to myself as candidate and elected Senate nominee, and to myself and other voters, and thus to members of a protected class of potentially associated voters created by Anderson. So I had that in a footnote, just that explanation of discrimination. Now, in this case, the state and the DFL abridge and deny voting rights using suspect classifications in order to support group rights as against the fundamental rights of individuals clothed in the constitutional rights of freedom of association and freedom of political expression under the First Amendment, United States Constitution. In Minnesota, a state law barring participation and voting by those who do not agree with proportional representation and group rights, see Minnesota Statutes 202A.16 Subdivision 2, Agreement with Party Principles, abridges and denies the vote in nominations of federal senators and representatives to whites, males, and straight voters, violating the rights of voters, including petitioner. And maybe just a little bit more explanation. It says, only those persons who are in agreement with the principles of the party as stated in the party's constitution, I'm referring to the outreach and inclusion provisions of the DFL Constitution, which mandate proportional representation, may vote at the precinct caucus. And Subdivision 3, decision by caucus vote, further provides that in case the right of a person to participate at the caucus is challenged, the principles of proportional representation are grounds for ousting the voter, because those are the principles. Now, as set out in the petition, all other jurisdictions, including Texas, California, and the DNC, Democratic National Committee itself, find this objectionable, evidently on constitutional grounds. See petition at page 12 and 38 to 40. Compare this to the Texas group rights provision. Quote, no test of membership in or oaths of loyalty to the Texas Democratic Party shall be required or used if it has the effect of requiring prospective or current members of the Democratic Party to acquiesce in, condone, or support discrimination on the grounds of race, sex, sexual orientation, gender identity, etc. Now, this quota is just such discrimination. Group rights are discrimination against those who are not in the protected suspect classification, such as a race or a gender. And so I think that that is a question that the U.S. Supreme Court has to deal with. They need to announce that they'll hear that and deal with it, and that they've sent it back to the state to send to the Senate, because that is their jurisdiction. Now, at the same time that they were doing this discrimination, my opponent for the U.S. House, Betty McCollum, used debates, televised or broadcast on radio, to assert she was fighting for voting rights. And you hear it all around the country right now. They're fighting for voting rights, aren't they? Voter suppression. Well, when I began to oppose this proposition, pointing out that her party was backing group rights with my rap video, Make It Count, which says, McCollum says her party's fighting for voting rights, but her party's setting quotas for blacks and whites, and it goes on. So she's got quotas, and yet she claims to be fighting for voting rights. Well, at that time, the Secretary of State, when I could have put that out with emails to all the registered voters in the 4th District, reversed the years of practice of his office of selling registered voters' email addresses through the office and of using them to fund and support DFL campaigns, including his own, and denied any email addresses to me, petitioner. When I filed a federal case and a state election contest very quickly, the Minnesota court violated the contest provision by refusing to order that the contest filed in Ramsey County be allowed to proceed as required to the U.S. House. And they thus usurped the power of the Houses of Congress to determine the elections and qualifications of Minnesota's senator through the aid of Minnesota's Congressional Office Contest Provision 209-12. The governor and Secretary of State violated the contest tolling provisions by issuing the election certificate to McCollum while the contest was pending. In the next election cycle, 2014, I won the nomination of the Independence Party for U.S. Senate. But DFLer Al Franken negotiated for debates, which excluded the Independence Party per se, and therefore me, from all debates for Senate. The Minnesota court refused to hear an election petition filed before the 2014 election to address the exclusion from all public broadcast Senate candidate debates, saying it had narrowed the scope of the petition provision. So in other words, the court said that we can't hear this because we don't we don't hear things like this. But this narrowing reversed, among other things, the 2002 case of Moore versus NPR, involving my party's Senate nominee then, in 2002, who was excluded in a debate negotiated by Vice President Walter Mondale, in which a Minnesota court, he was a former vice president at the time, but he was running for Senate against Norm Coleman. I believe, he's the one who lost it to Norm Coleman, and Al Franken took it back, in which a Minnesota court did hear a suit by our party challenging the exclusion of Senate nominee James Moore from a single NPR public broadcast debate after the tragic death of incumbent Paul Wellstone. And that did also rely on this self-same petition provision, which now they claim they're not interested in this kind of thing anymore. Now, after the election, a contest was filed after my election. And the Minnesota court appointed, this time they appointed the panel to hear it. That contest, however, was derailed by the December 19th certificate. And I appealed to void those proceedings, and while the contest results were on appeal at the Minnesota court, that is the post-judgment motion, I filed an election petition to decertify and reinstate the contest. Decertify Franken and reinstate the contest, which petition was denied, and now I'm seeking certiorari of that appeal. The remedies sought by this motion are fairly included within the questions in that petition. See Rule 14.1. Respondents have received the petition and exhibits, but rather than file a high-quality brief in opposition seeking to explain why the court should not hear the case, they made a calculated decision to file nothing. As such, unless the court orders a response, respondents have failed to present any reason the court should not hear this based on misstatement of fact or law in the petition that bears on what issues properly would be before the court if certiorari were granted, Rule 15.2. As such, respondents' counsel have played the odds and let the court deal with the petition without even filing a brief in opposition. Petitioner urges the court that this petition may have merit and to request a response to the petition because the petition is prima facie meritorious and the matter is complex or difficult enough to make presentation of the views of respondents, the governor, Secretary of State, Attorney General, appropriate. Alternatively, based on the record before this court, which is uncontested by respondents, the court should grant the relief supra sought by this motion, which is have the governor let me go through the courts to send this on to the U.S. Senate where these can be dealt with as part of that election contest, which was wrongfully blocked. The undisputed actions which were tolerated unconstitutionally by the Minnesota court and its panel usurped the power of the Senate and prevented the operation of the Constitution under both Articles Sections 4 and 5. So Article 1, Section 4 and 5 were both not allowed to operate. Section 4, again, is the one that allows the states and actually mandates the states to prescribe in advance election laws for congressional office, which will be followed. And Section 5 is in the event of a contest that the sole judges in that contest must be the U.S. Senate or the U.S. House, not some courts to try to muck it up and block it. Petitioner argues it is the duty of this court to give effect to those provisions, to guarantee Minnesota a Republican form of government, and to give effect to Sections 4 and 5 supra. Further, in order to ensure the individual voters, their candidates in the Independence Party and petitioner as their 2014 Senate nominee a Republican form of government. Under Article 4, Section 4, Clause 1 of the U.S. Constitution Guarantee Clause, this court must give effect to these Minnesota election laws authorized and passed thereunder. I have set forth, trying not to act too much like the King's Speech where he couldn't quite get it out. I'm just going over something that's on the computer. Now, I set forth essentially 5 practices I felt were discriminatory against the voters. And these were raised as federal questions in the contest filed in the Minnesota panel. And I set that out in the statement of the case in the petition. They are thus intended for the Senate, a coordinate unit of the federal government to which this political question is clearly committed by sections 4 and 5. This motion asks that the court refer this to the Senate with adequate discovery to inform the issues with facts respondents and the Minnesota courts panel have not allowed to be disclosed, by ordering the governor to reinstate and allow the Minnesota contest to proceed lawfully with full discovery. And the panel shut down all discovery and quashed the interrogatories served on Secretary Ritchie, Senator Franken, OSS Counsel Burt Black, and OSS employee Nancy Breen. Judge Vandenorth said petitioner could get senators to sponsor a hearing out there, or here in St. Paul, and conduct their own discovery. So the discovery implicitly provided for in Minnesota Statutes 209-12 was not needed. Petitioner also seeks to depose and get documents from these officials. And so as I say, I have attached those interrogatories for the court to look at and see that this was not just fooling around with one single statute, and that they had blocked discovery, and that you can hardly gather evidence without discovery, can you? Okay, so all these points have been the subject of action by the Senate and House legislation. Everything I'm talking about is something the Senate and the House have passed laws in the Constitution about, including the writing of the Constitution, to regulate federal elections through legislation, and are thus deemed to modify and constitute the prescribed manner of election by the members of Congress, and must be applied by the Minnesota courts, and yet they have not been applied. I never mentioned the Constitution. Now, as I discuss, under Minnesota law, validity of elections is a ground to voiding and contesting an election, and such grounds describing constitutional violations and irreparable injury from the wrongful acts asserted in this petition, the courts below, can be included as points in a contest intended for a determination by the United States Senate or House of Representatives. But the position implicitly taken by the Minnesota court in refusing to allow the contest to continue is that the court has determined such grounds may not be the subject of any election petition or contest. The court below relied on equitable grounds in 2012 to refuse to consider them. And specifically, in Carlson versus Ritchie, 812-2286 from Minnesota Supreme Court 2013, they said, Latches bars claims that petitioner was aware of before the 2012 general election, but failed to assert until after that election. So that's an equitable remedy. It's contrary to the law and Constitution. While refusing to act, and they also refused to act on the county judge's bar of the contest, which had been filed from the House of Representatives on grounds of requiring an additional filing fee that was not paid at the time, and probably could not have been paid. And then relied on its narrowing interpretation of the election petition scope in 2014 that I've mentioned, but they didn't just exclude the debate question, they excluded all questions except the vote count. And so they refused to command the governor to withdraw and recertify the Senate race, asserting inter alia, among other things, res judicata. That's another equitable provision. It says, well, it's just not fair that this should be brought up over and over. That's res judicata. It's already been decided, or could have been decided. It's an equitable remedy. And we've prescribed election laws under the Constitution. Those are the ones that have to be followed. Now, as a result, all the discriminatory practices alleged have been shielded from any remedy, and so would be continued in the 2016 elections. And this failure to remedy these in 2012 or 2014 has resulted in the elimination of the Voters' Independence Party and many more precious rights. The petition relies on Morgan and a line of cases to commit the contest not to Minnesota courts in any way except as spelled out in the Minnesota election law. This, in turn, is drawn from Baker to that's Baker versus Carr, to define the role of courts in a political question, which the election of senators clearly is. As such, the Minnesota courts must not act as courts in determining a congressional election contest under 209-12. The political question doctrine should be applied to this case. Instead, they carry out court-like functions as committed to them as a coordinate political department in the state's prescribed manner of electing a senator. To be clear, their role is limited. They're not to do everything that they usually do when they're a coordinate unit political department of the state. This is the integrity of the elections are carefully protected from the Minnesota Supreme Court, and they just charge ahead, disregarding those protections, and thus our democracy is lost. Now, they cannot choose to supplant the clear statutory commitment of these duties to the U.S. Senate by adopting equitable principles or their own preferences or wisdom. In this case, their abuse of their contest and petition role has barred the operation of the Constitution, whatever their political accomplishments. Their role is specifically prescribed in Article 1, Sections 4 and 5. It is not an invention of the Minnesota court, and indeed, the restraint on their power in influencing election outcomes and conduct as a political question is strictly prohibited or prescribed by Sections 4 and 5. In Smiley versus Home, 285, that's a 285 United States Reporters 355. This is a 1932 case, certiorari to the Minnesota Supreme Court of Minnesota. In a case like Baker versus Carr or Bolden versus City of Mobile, Alabama, that both involved redistricting, this court held, quote, the subject matter is the times, he's quoting from Article 1, Section 4 of the Constitution. The subject matter is the times, places, and manner of holding elections for senators and representatives. It cannot be doubted, says, I believe it's Chief Justice Jerome Hughes of the U.S. Supreme Court in 1932. It cannot be doubted that these comprehensive words embrace authority to provide a complete code for congressional elections, including protection of voters, prevention of fraud and corrupt practices. In short, to enact the numerous requirements as to procedure and safeguards which experience shows are necessary in order to enforce the fundamental right involved. And these requirements would be nugatory if they did not have appropriate sanctions in the definition of offenses and punishments. So it says that little phrase, times, places, and manner, calls for enforcement. Now, the Minnesota court and political establishment simply cannot cast these aside, or the protections of the voters are irreparably injured and lost. Petitioner is likely to succeed on the merits. Petitioner seeks to compel the governor to follow the Senate rules and Minnesota election law and not take action to short-circuit the election contest provided in Minnesota election law. U.S. Constitution Article 1, Section 4 requires the state of Minnesota and all states to prescribe in advance these times, places, and manners in which the senators will be elected. Respondents argue that there exists no procedure for seeking relief from the alleged unconstitutional actions raised, including any review under this court's precedents in the Minnesota court. They argued January 5th that my points were baseless. But as the precedents in Minnesota election law hold, elections must be valid for anyone to take office on that basis. See Sari versus Gleason, S-A-A-R-I versus Gleason, from 1914, cited with approval by Pavlak versus Groh, that's Joan Groh, that's from 1979, both from the Minnesota Supreme Court. And in Sari, they said, we think that a statute prohibiting corrupt practices in elections and preventing any candidate employing corrupt means to obtain an office does not, in any proper sense, impose a new test of eligibility to office at all. It simply excludes a candidate employing unlawful means from enjoyment of a particular office under an election which his own unlawful acts have rendered of no effect. It prevents his reaping the benefit of his own wrong. It says, not that he is ineligible to this office, but that he must use honest means to obtain it. By extension, I'm not quoting now, by extension, the same principle precludes the stripping of major party status for Minnesota voters based on unlawful and dishonest means of the Democrats and Republicans. See Rule 22, Senate Rule 2, which says that they have to follow Minnesota law. It also requires a duly valid election, canvassing and review when appropriate, because it provides, quote, the language must be adhered to or the certificate will be rejected. The Senate will reject the certificate from Minnesota and return to the state for recertification, unquote. The governor did not adhere to the language because he did not comply with the very state law he cites in the cover letter to the Senate. That is Minnesota Statutes 204C.40 subdivision 2, the tolling provision. This is from 2014. He changed the law after that, which reads in pertinent part, in case of a contest, an election certificate shall not be issued until a court of proper jurisdiction has finally determined the contest. And as I say here, this is the provision that has been removed by repeal by the legislature and the governor in 2015. The state's representations, January 5th, to the Minnesota Supreme Court attempt to meet this standard, assuring, quote, the three-judge panel trying the matter filed its final judicial decision pertaining to the Senate contest on December 19th, unquote. But Minnesota Statutes 209.12 clarifies that the earliest time and circumstances this final judicial decision prerequisite can accrue is, quote, after the time for appeal is expired, or in the case of an appeal, after the final judicial determination of the contest upon application of either party to the contest. So all these things have to take place before this can issue, because this is what then goes to the Senate. Now, only then is the contest finished, and all this material is then to go to the Senate. But these conditions never occurred in this Senate contest because, for the reasons preferred by the state, December 19, 2014, the governor had already signed and sent the certificate. It is impossible to argue that this constituted final determination of the contest for a number of reasons. The December 19th action was a deliberate and well-designed partial determination of the contest. It concerned itself only with a single issue, ironically the very issue not contested. That is the accuracy of the contest. However, as the petition points out throughout the statement of the case, federal issues regarding the wrongful conduct of the election, which required compliance as well with the state election laws, including the availability of courts for redress to grievances about that conduct, were the sole basis of the contest. And these were not addressed and could not be appealed. It is apparent that the state's tacit position, implied by Attorney General's assertion that the contest was baseless, is that the state court in Franken versus Pawlenty, and this was a case really in the election with Coleman, had excluded all other points regarding validity from contests by its misapplication of the statute in that case, in dicta that were not material to the disposition of that Supreme Court case with Al Franken and Norm Coleman. It was a case which was, in fact, solely regarding the accuracy of the count, which showed Franken with a higher vote total at the time than the Republican Norm Coleman. David Lillyhaug, who has since been appointed by the governor to the Minnesota Supreme Court, was the lead Franken attorney in that case. However, even if the Franken opinion was a fair reading of the state law, which it is not, in order to seek a determination in the Minnesota court by appeal, which is required for the issue of the certificate, the partial determination of the contest with no opportunity for appeal, and in fact no notice to petitioner of the right to take appeal, could never fulfill the requirements of the tolling provision. The state also argued in the Minnesota court that the governor's action was justified because on the afternoon of December 19th, I did not attempt to stay him from issuing the certificate pending appeal, and so he issued it. And finally, when the election petition seeking compliance with the tolling provision by withdrawal of the certificate was filed, the petition whose review is sought here, the governor signed a law repealing the provision altogether. For reasons infra, this conduct is not only unconstitutional, but contrary to public policy, and it justifies the remedies sought in this case. In this motion. Now, respondent's position that the certification was justified that afternoon does not comport with the state election law. There was no reason for me to be calling the panel that day, when I was still briefing the issues as requested by the panel, to see if they had finally determined the contest. The partial judgment had not been served on me. Even if it were served, the contest provision clearly states there is a provision for appeal of that partial judgment before the certificate could issue. And maybe here's a little more explanation of that. Of course, all the Minnesota courts are permitted to do in this contest is to take and certify evidence and then forward it to the Senate with the certificate and cover letter, if requested by either party. So the Senate may review these additional points. So that explains what their actual role is. Now, and in fact, as soon as I received the preliminary partial order, as my appeal for the mandamus states was actually entered on December 18th, just after the trial, not the 19th, I immediately filed with the Minnesota court to stop the imminent issuance of the certificate. Saying the partial order subverts the law, I state my concern, quote, that Secretary Ritchie may send Al Franken's election certificate to the U.S. Senate Secretary immediately without a final judgment and without the files, records, and evidence taken in this proceeding on the contest actually filed. So there is no way the state can justify this treachery. In fact, what the Minnesota courts have done is act as judges in this election contest reserved for the Senate as the sole judges. See Morgan. Morgan, as most election cases, dealt with the question of which candidate received the highest number of votes legally cast and was therefore entitled to receive the certificate, but could not if points were raised regarding his right to office, such as corruption and invalidity of the election. It did not concern the validity of the election because of dishonest means of achieving office or constitutional concerns. I do not know if other states have this provision. However, it is clear from Minnesota election law, which has not been modified by Congress as it could have been under Article 1, Section 4, that validity is a ground of challenging the right of Al Franken to the office of U.S. Senator. And the question for the Senate in the contest the question for the Senate in the contest is whether these practices constitute irregularity in the conduct of an election and grounds of deliberate, serious, and material violations of the Minnesota election law so as to invalidate the election, or to call into question the validity of the results, including the inference that the Independence Party has not reached the 5% Minnesota threshold requirement so as to lose the civil rights and or privileges of having a spot on the general election ballot. Petitioner is likely to suffer irreparable harm in the absence of preliminary relief. If the motion is not granted, the rights petitioner asserts are lost by respondents' practices will be irreparably lost. What can be done is going forward. And the issue of the irreparable injury and loss of rights to the voters is in addition to the core issue of the right of the incumbent Senator Al Franken, whose certification and related shutdown of the election contest is the subject of this motion. Reinstating the contest and allowing it to proceed with discovery will begin the restoration of these Independence Party rights in the ongoing 2016 elections, as well as clarifying what kinds of practices can be used by these states and their major national political parties to promote group rights and party rights when those practices infringe on the free association and free expression rights of the voters, the heavy burdens cited in Anderson. And so the loss of such core rights is by their very nature irreparable. Only by being documented as Minnesota law provides and brought to the U.S. Senate in contest can that restoration occur. For they are not merely personal, but core fundamental rights on which the very notions of freedom through a republican form of government rest. These injuries, as a result of the discrimination detailed in the petition, have long occurred and have already inflicted irreparable injury through frustrating the ability of the voters to associate and express their views. There are two key parts to the First Amendment. One is association, to put a candidate on the general election ballot outside the two major national parties, Anderson at 781. And what does it say? To quote, "A burden that falls unequally on independent candidates or on new or small political parties impinges by its very nature on associational choices protected by the First Amendment, and discriminates against those candidates and voters whose political preferences lie outside the existing political parties. And in the context of a presidential election, I'm running for president, and perhaps others will run for president from the Independence Party as well. I've heard of Jesse Ventura, for instance. Of course, Donald Trump is running for president, and he was the Reform Party winner in California of the primary for president in I believe it was 2000. So in the context of presidential election, said the Anderson Court, state-imposed restrictions, which all of these are, implicate a uniquely important national interest. So that is what Anderson said. And the other, besides this freedom of association that was set out in Anderson, is political expression. Now, when the voters go to the polls, they engage in really the highest form of political expression, to vote for a candidate who represents certain policies they identify with. And just to explain that, and actually, I think that footnote is wrong. So I am sorry, but let's go on with what Anderson said. When the voters go to the polls, they engage in the highest form. Now, in turn, that candidate has to have freedom of expression to inform the voters of their positions, so they are able to take that vote and express their views by supporting them. So this is all freedom of political expression, the voting and the expression of the candidates. These essential functions of elections, both association and expression, are all suppressed by the practices detailed in the contest and the petition for certiorari here now. The loss of the party blocks association of voters to put a candidate on the ballot whose views cannot be represented. That loss and each of the protested practices inhibit the ability of the candidates to be heard, where they are clamoring to get their views out and before the voters. In the name of democracy, a candidate cannot go to the DFL caucuses to discuss his views in Minnesota. He runs up against institutional goals to displace him because of his race and his sex. This is institutionalized racism and sexism in the election, and this is barred by the 15th and 19th Amendments to the U.S. Constitution and also the 1st and 14th Amendments because it's discrimination. He cannot reach voters with his message by the voter email addresses collected by the state because that would be valuable in the election, according to the Minnesota courts. His concerns about these snowballing practices may not be heard in the fora designated by the election laws for Congress. And that is the correct footnote there, which is a claim that the district court wrongfully refused to accept an election contest, said the Minnesota Supreme Court, does not fall within the scope of Minnesota Statute 204B as related to an election. Now, how crazy is that? Now let me talk a little bit more about what Anderson actually says about why the Independence Party has to be on the ballot. It is to be expected that a voter hopes to find on the ballot a candidate who comes near to reflecting his policy preferences on contemporary issues. This is the U.S. Supreme Court citing Lubin versus Panish, I believe, from 1974. The right to vote is heavily burdened if that vote may be cast only for major party candidates at a time when other parties or other candidates are clamoring for a place on the ballot. That's where I got the clamoring. I'm clamoring, we're all clamoring. This is from Williams versus Rhodes, 393 U.S. 31, all U.S. Supreme Court cases. And so the Minnesota court then effectively affirmatively barred access to the federal legislature, usurping Congress's own fundamental rights. These are rights that are cherished by the Congress, not by me, not by the Independence Party. No court can go in, it's long been established since English common law, that no court can go in and take and decide who the members of that legislature are going to be. And why is that? Well, because a king or a president or a party could take away the actual representative function of that assembly, because they would not be allowed to determine who had actually been elected. So if there's a question, you have to put it in their hands, and further, they are also the United States that has a constitutional duty to guarantee a Republican form of government. That means free and fair elections to elect representatives in their body. So there's a certain tension there. And public broadcast debates for the office for which he has been nominated by statewide voters go on without him supposedly because he's not a Democrat or Republican. That's what the organizers in Duluth said. And because he needs to poll 10% in the polls that the University of Minnesota looks at, that's Larry Jacobs, who was relied on by CBS to exclude me from that debate, in order to get in the debate, even to encourage voters to consider his views. Although I need just 5% in the vote to keep my party on the general election ballot in 2016. So why should the requirement be twice as high as the requirement for the party to go forward? It's a clear decision to get rid of the party. Now, all of these injuries needed to be justified under the Anderson line of cases. Okay, so these were all injuries, and Anderson, the Supreme Court case, requires that they be justified. As this court has said, although these rights of voters are fundamental, not all restrictions imposed by the states on candidates' eligibility for the ballot impose constitutionally suspect burdens on voters' rights to associate or to choose among the candidates. And so Minnesota has to justify the heavy burdens I contested. To quote, a court must resolve such a challenge by an analytical process that parallels its work in ordinary litigation. Notice that's not ordinary litigation. It must first consider the character and magnitude of the asserted injury to the rights protected by the First and 14th Amendment that the plaintiff seeks to vindicate. It then must identify and evaluate the precise interests put forward by the states as justifications for the burden imposed by its rule. In passing judgment, the court must not only determine the legitimacy and strength of each of those interests, it must also consider the extent to which those interests make it necessary to burden the plaintiff's rights. Only after weighing all these factors is the reviewing court in a position to decide whether the challenged provision is unconstitutional. And I omitted a line of cases, and I'm trying to cut down actually on the footnotes to make this very clear and easy to follow. Barring that remedy from Minnesota courts and the Senate ensures that those injuries will not only be irreparable but permanent. Petitioner is not concerned about my ability to defeat duopoly candidates when those First Amendment rights are secured. My concern is that for some reason those in power will permanently erect and leave in place these barriers to the First Amendment, dismantling our Republican form of government. That's an irreparable loss. In order to restore the status quo intended by the Constitution and the laws as described here, election officials in Minnesota must be commanded by this court to restore the party rights lost, because otherwise will be irreparably damaged. Then the balance of equities tips in petitioner's favor. Now, respondents are not allowed to create equitable arguments to bar a congressional elections contest under Minnesota Statutes 209-12. Therefore, their so-called equities are worthless in this determination of the balance. Laches bars claims that the petitioner was aware of before the 2012 general election, but failed to assert until after that election. And footnote, and just to augment that, this court in 2013 also ruled, well, what they ruled is, with respect to Carlson's first argument, we have not previously used a statute of limitations. The argument was that the statute of limitations should take effect over the equitable remedy because, in fact, Minnesota set up a contest provision, and you cannot file a contest until after the election, and you must file it within 7 days, and I did. And so they're saying, we're going to throw this aside. But they said, we have not previously used a statute of limitations analysis in election contests. Well, election contests have statute of limitations. Petitions might have equitable concerns, but not in election contests because it's in here. I'm not going to argue that if somebody puts up a lawn sign and you wait until the last day before the election and then you try to block the contest because of the lawn sign, that could not be barred. I would say for diligence that could be read in, I don't think you need to go to a laches construction, which is equitable remedy, which is if you're going to injure somebody else, you can't take that action except within a certain time after discovering that you have a right to take it. It doesn't apply here. And so what they said then, and again, I'm sorry. So, and they declined to do it in this case. They declined to use the statute of limitations. In the context of election-related challenges, so they're lumping together contests and petitions, which I think are different, we focus not on a limitations period, but on whether a reasonable, valid excuse demonstrates that the petitioner could not have acted more expeditiously. So the court overruled the statute as to when a contest can be filed, preferring equitable remedies. And here's what the law says. 209.021, Notice of Contest, Subdivision 1, Manner, Time, Contents. Service of a notice of contest must be served and filed, so the service must be served, within 7 days after the canvass is completed in the case of a special and general election. So it must be done after. And it must be done within 7 days after, and they just threw that out the window. Laches, used to void election laws mandated by the framers. Such audacity. Equitable excuses by the Minnesota court are not valid in an election contest or to bar an election contest from going to Congress. And then relying on more judicious application of equitable remedies, the court below held the contest would not be heard, since they say issues raised and litigated in an elections contest, which could have been litigated, are res judicata by the judgment rendered therein. They're citing a case about a school district election, Green versus Independent Consolidated School District from 1959, which says all issues raised by the pleadings herein relative to the validity of the challenged election are concluded by the decision of this court, unquote. I think it's a pretty bad case to block this from the Congress. Also, they refused to enforce the tolling provisions, and now the state has got rid of the tolling provisions altogether, but only for federal office. For the state, they still have tolling provisions. State legislature is protected. They wouldn't pass a law which gets rid of their control over their membership, but they'll pass one that gets rid of Congress's control over their membership if it helps their two-party system. This is atrocious. Now I believe they have committed deliberate and serious violations of our Constitution by abusing equity and their ideas. Speaking of the court now. Moreover, there is no way the use of unlawful release of the election certificate stopping the contest at the panel could ever be res judicata. It had never happened previously in a contest, and no court had ruled on it. It couldn't have happened. As stated in the petition already, this court below never even mentioned in the governor's release of the certificate in dismissing the election petition, thus denying any rehearing or further proceedings on the banned contest. So they don't talk about that. Here's what the petition was based on, that he released the certificate, and it's the one issue, again, that they don't address. And yet they think that this should not be overturned by the Supreme Court. Further, granting the motion is in the public interest. As the Anderson Court distinguished supra, an election contest is not, but parallels ordinary litigation. This contest and petition is not about being a sore loser. It is not baseless. It is about the nation's most important public policy, our freedom based on the rule of the Constitution in federal elections. The public interest to make possible my clamoring and others, and participation in voting in federal election. Relying on the U.S. Constitution to have my right to be heard, to have a voice. Compare King George VI, depicted in the King's Speech. And it raises an issue, the elimination of the Independence Party on the basis of the challenged election, and that party must have a voice. It is in the public interest in this case and motion to preserve and restore the civil rights to vote, to associate and engage in selecting candidates with policy views outside the DFL and GOP. Do they have policy views in those parties? I thought you just kind of follow around whatever the top big cheese tells you to do. To the individual voters, these need to be restored, which were lost due to the respondents' actions and omissions and bald refusals. These individual and fundamental rights were lost through destruction of the Independence Party by tearing up the Constitution during the election. Compared to Tashjian and Yilfeng Supra, to allow this to go unprotected in this large-scale way, taking away the voters' membership or participation without a valid election, is indistinguishable from eliminating the Republicans from a state or eliminating the Democrats. With every election, there is someone who wins, somebody who loses. But the major parties, if they lose, hope to win some offices and to have a party to come back another day. In this case, that's all been completely lost for independent voters. The public interest is to preserve at least two parties. In passing on the Constitution, Congress rejected George Washington's admonition against the dominance of parties and factions. And what we have instead is Anderson. The states run by the two parties will have the right to regulate elections for Congress and President, but if their actions or omissions impinge on the associational rights by imposing a heavy burden so voters can't participate, a court will require that state to justify it. This is to rely on and protect the First Amendment, not Washington's fears, however well-founded and wise. It is not that we want the competition of Democrats and Republicans. What we want, as the Anderson Court said, is, quote, a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open. New York Times versus Sullivan, 1964. And these are served when election campaigns are not monopolized by the existing political parties, and that's language straight from this court. They talk about discriminating and monopolizing the election campaigns. And that's what's happening here. The public policy announced by Anderson falls in favor of granting the motion, since as the identity of likely major political parties or party nominees is now being shaped, and the independents in Minnesota are absent because of this indefensible loss. And the Supreme Court said, since the principal policies of the Major parties change to some extent from year to year, and since the identity of the likely major party nominees may not be known until shortly before the election, this disaffected group of people who are not down with the Democrats or Republicans will rarely, if they're the Tea Party, they'll rarely, if ever, be a cohesive or identifiable group until a few months before the election. And we see the jockeying in the 2016 election going on right now. We need to organize, we need to associate, and we have the right under Minnesota law to be on the general election ballot, because without these serious material and deliberate violations, actions, omissions, and refusals, the Independence Party would still be extant in the respondents' offices, the governor and secretary of state, participating in the 2016 election as a viable major party established by the Independent Voters Associating, which they did. That's where this law comes from. Based on the above arguments and facts on the petition, and based on the likelihood the petition will prevail, that is to say, you will provide for the decertification and for the continuation of the contest to the Senate, the likelihood of irreparable injury to petitioner and those they represent. Based on the weight of the equities and the public interest, petitioner respectfully urges the court to grant this motion. I'm Steve Carlson. I'm running for president. If you have listened so far, I think you have gotten a serious message. This affects independent voters and candidates all across the country. We are now 53%. We are the majority of the voters. And this is what is being done to stop us. And whether you're a libertarian, Green Party, here they just established the Green Party even as a minor party. Whether you're an independent supporting Bernie Sanders, or you're an independent supporting Donald Trump, or a Republican supporting Donald Trump, your rights are impacted by this. A lot of times the Republicans seem to say, well, this is okay with us. If they have quotas that are turning the Democratic Party into sub-parties and subgroups and group rights, which, as I point out in the petition, is barred by the Bolden holding of this court, where Thurgood Marshall tried to say there should be group rights and this should be the basis of redistricting. And I'm not sure actually where that is right now. We have many redistricting cases and voting rights cases even ongoing right now. But it was rejected by the court. And I believe that it is because that you can't discriminate against the voters. It's possible to do it, and the Constitution bars it. Beyond that, each of us cannot be discriminated against practices which abridge and deny our voting rights by taking them away and giving them to women, giving them to a minority group, giving them to homosexuals, to immigrants, to ethnic groups, because that is chipping away piece by piece at the solid foundation, the rock on which our Constitution and our democracy, Republican form of government, are based. And that is our individual rights of free association and free speech that allow us to say that we have a democracy. I'm Steve Carlson. I'm running for president. And again, thank you for looking at this.